Last 5 seconds. Ready? Start. The purpose of the aforesaid clauses appears to be to prevent a possible challenge to the multiple stage tender process midway. The High Court has construed that the said clauses would restrict the right of the bidders to seek judicial scrutiny of the tender process. However, the High Court does not seem to be wholly true. The High Court ought to have appreciated that first of all, Clause 28 is a confidentiality clause. On general reading of the aforesaid two clauses, it can be said that it does not take away the right of the bidders to seek judicial scrutiny at all. Only the stage and time to know the reasons, and thereafter if the unsuccessful bidder is aggrieved can seek the remedy which is deferred till the final decision on award of contract is taken and communicated. As observed herein above, the object and purpose would be no interference in the tender process in between till the final decision to award the contract is taken. By no stretch of imagination, it can be said that it takes away the right of the unsuccessful bidder to seek the judicial scrutiny of the tender process. After the final decision is taken to award the contract and the contract is awarded, thereafter it will always be open for the unsuccessful bidders to ask for the reasons to which the employer is required to furnish promptly, and thereafter the unsuccessful bidder may avail the large legal remedy which may be available to it, may be claiming the damages. The High Court ought to have appreciated that it is always advisable that in such a foreign funded mega project, delay may have a cascading effect and many a times have a financial burden due to delay in projects, and therefore there shall be minimal interference and or no interference till the entire tender process or till the award of contract is completed. The foreign funded agency therefore is justified in providing such clauses to prevent challenge to the tender process midway. A foreign funded agency who invests funds such a huge amount of such a mega project on bilateral talks between two countries is justified in insisting such clauses and to insist that the information relating to the evaluation of the bids and recommendation of contract award shall not be disclosed to bidders or any other person until information on contract award is communicated to all the bidders, and the grounds on which the unsuccessful bidders bids are not selected shall be provided thereafter. The object and purpose of providing the aforesaid clauses is very clear, namely no interference with respect to the tender process midway and till the final decision on awarding the contract is taken. Even we are also of the opinion that in a mega project which is funded by a foreign country, there shall not be any interference with the tender process midway till the final decision is taken to award the contract. The reason behind this is that any delay in such a project may increase the ultimate project cost and it may affect the future investment by the foreign country, which would never be in the larger nation's interest. Under the circumstances, the High Court has committed a grave error in holding that clauses 28 and 42 are patently illegal, more particularly in the absence of any challenge to the same, and also on the ground that once the original writ petitioner participated, having knowledge of the aforesaid clause in ITB, thereafter it was not open for the original writ petitioner to challenge the same. The original writ petitioner was knowing right from the very beginning with respect to the confidentiality clause contained in clause 28 and that grounds on which the bids of unsuccessful bidders are not selected shall be communicated only after a final decision to award the contract is communicated under clause 42. If the original writ petitioner was aggrieved, either it would not have participated and or ought to have challenged such clauses before participating in the tender process. Under the circumstances, the impugned judgment and order passed by the High Court holding clause 28 and 42 as patently illegal cannot sustain, and the same also deserves to be quashed and set aside. Stop.